So, in the recent times, we have seen that there has been a conflict between the Supreme Court and the Union government over the functioning of the tribunals, so that technically informed justice is delivered, and also to ensure that the burden on the high courts and the Supreme Courts is reduced. But in the recent times, we have seen that the executive, that is the union government, wants to control or interfere in the functioning of these tribunals. Hello and welcome to Prep Alpine, the next generation UPSC institution. We are continuing with our high yield UPSC series where we discuss some of the most important topics for your upcoming UPSC prelims examination that have the maximum probability of being asked in your exams. The topic for the day are tribunals in India. This topic is highly relevant from GS2 perspective as well as governance and ethics perspective, because here we are going to discuss the conflict that is occurring between the judiciary and the union government. This has been in news recently as there have been amendments related to the functioning of the tribunals, and the court has said that these amendments should not be done, or these changes should not be done, and there has been a constitutional conflict between the court and the union government. So let us start with the topic. In today's video, we'll talk about a very important topic from GS2, which is the tribunals in India. So, in the recent times, we have seen that there has been a conflict between the Supreme Court and the Union government over the functioning of the tribunals. So, before going further into the conflict, let us first understand that why, in the first place, these tribunals were constituted. So, initially, the tribunals in India were constituted to deliver faster justice, to deliver specialized justice, because people in the tribunals are specialized people from their field, so that technically informed justice is delivered, and also to ensure that the burden on the high courts and the Supreme Courts is reduced, and the complete resolution of the matter is provided by experts or field experts. But in the recent times, we have seen that the executive, that is the union government, wants to control or interfere in the functioning of these tribunals. So the key question that arrives here is, can a judicial body housed within the executive structure genuinely remain independent? Because as you all know that our constitution under Article 50 provides for division or separation of powers between the executive and the judiciary. And this tribunal is not a part of the judiciary but is a quasi judicial body whose sole objective is justice delivery. So now the court is asking that can the executive interfere in the working of the tribunals? So now let us understand the core of this conflict, that what is the view of the government as well as of the Supreme Court. So there are two key areas of conflict between the government and the court, one of which is the tenure of the tribunal members. So the government says that minimum 4 years is or maximum of 4-year tenure is enough to judge the expertise or to judge the performance of the members of the tribunal, and it also ensures rotation of office. On the other hand, the court says that the tenure must be longer and at least 5 years, so that because short tenures create dependence on the executive, and the court also says that there should be no clause of reappointment because that ensures dependence on the executive and partial nature of the members. Apart from this, the second conflict between the government and the court is about the age and the eligibility criteria. The government says that the minimum age should be 50 because the government says that seniority assures maturity as well as expertise, because more experienced people, that means more experience in the legal field, and that means they have more maturity and are experts in their respective fields. But the court raises a serious concern here, that we have abruptly excluded people below 50 who are highly qualified, in fact, so qualified that some of them are eligible to become High Court judges, and there is no justifiable reason given for this exclusion. But this is not it. This conflict escalated between the government and the executive or the Supreme Court in the subsequent years. First of all, we saw that in the Finance Act of 2017, the executive gave complete consolidated tribunal administration control under the center or to the center, which means that complete unsweeping powers regarding rules of the tribunals were given to the center. And the Supreme Court raised serious concerns about these rules, but still the functioning of the tribunals were allowed. Then in 2019, in the Roger Matthew case, the court struck down several provisions of this Act, Finance Act 2017, and the court emphasized that tribunal independence is a constitutional necessity and not just an administrative discretion. That just because the administration doesn't want it to have discretionary powers or to have independence does not mean that it can be done so, because tribunal independence is a part of the constitution. Then again in 2020, the government again decided to make some rules and replicate the previous provisions. The court again warned that repeated violations of its rule can be constituted as a contempt of court. However, in 2021, the government again introduced an ordinance that with the provisions that the court had already rejected. So this cycle of invalidation, then reenactment, then again invalidation, then again reenactment is not just a policy disagreement but a breakdown of constitutional dialogue, because both the executive and the court or the judiciary are required for the smooth functioning of our constitution. So now we must understand that the court here is not concerned just because of the age or the reappointment, but the larger question that if the tribunals are dependent on the executive, then this can harm the clause of complete justice as mentioned in our constitution. Apart from this, this cycle of invalidation, reenactment, and then again invalidation and reenactment is eroding the concept of judicial review or the power of judicial review that has been given to the Supreme Court by the Constitution of India, and it is a part of the basic structure of the Constitution. Apart from this, the Supreme Court also says that when the tribunals are placed at par with high courts in many scenarios, then why not can they have equivalent standards of independence? However, we have heard one side of the story. The other side of the government says that lawmaking is a part of the legislature, is a duty of the legislature, and the court must not interfere. The government also says that shorter tenures means more efficiency and seniority ensures expertise in handling complex matters. And lastly, the government gives the separation of powers argument that the judiciary must not interfere in the functioning of the executive. But this is not just a war or a conflict between the center and or the union government and the court, but there are many problems that have to be faced by the common man. For example, there have been widespread vacancies across the company law tribunal, armed forces tribunal, income tax tribunal, debt recovery tribunals, and even environment tribunals, causing large pendency of cases causing litigants to return to high courts and thus making them more prone to pending. And lastly, it has also challenged the regulatory sectors like the insolvency, tax, and the competition. Apart from this, a larger public problem that has emerged here is the loss of public faith because justice delayed is justice denied. So, what is the solution? The solution is that we must establish a commission, the National Tribunals Commission, as advised by several expert committees to ensure the appointments and the service conditions of these tribunals. Apart from this, we must ensure that the tenure should be secure, uniform, and non renewable to ensure complete impartiality. Then we must also have transparent, balanced, and balanced selection committees to select the members of these tribunals. We must rationalize and consolidate the complicated landscape of Indian tribunals where there are multiple tribunals for similar matters. Apart from this, the number of vacancies that have increased in the recent years due to the conflict must be filled as soon as possible. And lastly, we must ensure that the ideals of our constitution of complete justice must not be eroded. Because once the idea of justice is delayed or denied, the loss of public faith is ensured and the fallout of the constitutional ideals becomes a necessity. That's all for this video. If you want more such content, please subscribe to the channel and keep watching Prep Alpine. Thank you.